This video is for educational purposes only and not legal advice. All names and events are fictional. Some content was generated using AI.
What is this?
If you've ever been served with a lawsuit and thought, maybe if I ignore it, it will just go away, think again. Here's what really happens when you throw a lawsuit in the trash. It starts when the bank files a complaint. You get served with official court papers. From this moment, the countdown begins. In most states, you have 20 to 30 days to respond. Ignore it, and the bank moves to the next step.
I don't have time for this.
By ignoring the complaint, you hand victory to the bank. They file for default judgment, which means the court rules against you without even hearing your side.
Prepare and file a default judgment application. The defendant hasn't responded.
Welcome back to Legal Matters on the Air. Today we're diving into a topic that sounds technical but can hit very close to home: default judgments and what happens when a creditor enforces one. Joining me is Professor Mark Daniels, an expert in civil procedure. Professor, thank you for being here.
Thanks for having me, Sarah. It's a really important issue and one that many people don't understand until it's too late.
Let's start at the beginning. What exactly is a default judgment?
A default judgment is essentially the court's way of resolving a case when the defendant doesn't respond. If someone is properly served with a lawsuit, meaning they get official notice through a summons and complaint, they're required to file an answer by a strict deadline. If they ignore it, the court can declare them in default and enter judgment in favor of the other side, usually for money damages.
So ignoring a lawsuit doesn't make it go away. It makes you lose automatically.
Exactly. It's one of the biggest misconceptions. People think, if I don't respond, maybe the problem will disappear. In reality, it hands victory to the plaintiff. The court system has to move forward, otherwise defendants could stall justice just by refusing to show up.
Let's talk about the flip side. If you're the plaintiff, say a bank or small business owed money, what steps are involved in getting that default judgment?
It's usually a two-step process. First, you ask the court clerk to enter the defendant's default, which formally locks in that they didn't respond. Then you request the actual judgment. If the damages are straightforward, like an unpaid invoice, the clerk can sometimes enter the judgment without a hearing. But if the damages are less clear, say pain and suffering, then a judge has to hold a hearing and decide what amount is fair.
Okay, let's say the judgment is entered. From the defendant's side, is there anything they can do at that point?
Yes, but time is critical. A defendant can file a motion to set aside the judgment, but they need a valid legal reason. For example, if they were never properly served with the lawsuit, or if they had a serious emergency that made it impossible to respond, courts may reopen the case. And often, the defendant also has to show they have a real defense to the claim, not just an excuse for missing the deadline.
So let's move forward to the part people really feel: the enforcement. Once a creditor has a judgment, what tools do they have to actually collect?
That's where the execution of judgment comes in. There are several main tools. Wage garnishment, where part of your paycheck is withheld and sent directly to the creditor. Bank levies, where your bank account can be frozen and drained to pay the debt. Property liens, which tie up your house or land so you can't sell it without paying off the judgment. And, in some cases, sheriff seizures, where a car or other property can be taken.
That sounds pretty aggressive. Are there protections for debtors?
There are. Federal and state laws limit how much of your wages can be garnished, and certain funds, like Social Security, veterans benefits, or unemployment checks, are usually exempt. The idea is to balance the creditor's right to collect with the debtor's right to basic subsistence.
What about being what people call judgment-proof?
That's a practical term, not a legal defense. It means you don't have income or assets that a creditor can realistically take. The court can still issue a judgment against you, but if your wages are protected and you have no property, collection may not be possible, at least for now. But circumstances change. A new job or inheritance can make you collectible years later.
Speaking of years, how long does a judgment last?
It depends on the state. Anywhere from 5 to 20 years is common. and many states allow creditors to renew a judgment before it expires, effectively extending it for decades. So ignoring it doesn't mean it goes away. It often just hangs over you.
Last question. If someone does finally pay off a judgment, is that the end of the story?
Not automatically. The creditor has to file what's called a satisfaction of judgment, which tells the court the debt is paid and clears any liens. If the creditor doesn't file it, the debtor may need to ask the court to force the issue, just to make sure their record is clear.
Professor Daniels, this has been eye-opening. Final word for our listeners?
Don't ignore a lawsuit. That's the fastest road to a default judgment. And if you already have one, act quickly, know your options, and consult an attorney. The stakes are too high to just hope it goes away.
Great point. Thank you for joining us.
If the defendant does not timely file a responsive pleading and the plaintiff requests a default judgment, the court may enter judgment in favor of the bank. Once judgment is entered, the bank can legally collect, and this is where things get very real. Collection tools include several legal methods, each designed to recover the judgment. For example, sheriff seizures, cars, or personal property may be taken and sold to satisfy the debt. Liens on real estate, a claim is placed on homes or land which must be satisfied before the property can be sold. Wage garnishment, a portion of the debtor's paycheck is automatically deducted. Bank levies, funds are frozen and withdrawn directly from bank accounts. Debtors' exams, the court can require the debtor to appear and disclose assets.
I'm sorry, but we can't approve your loan application at this time.
Even though judgments no longer appear on your credit report, they still have a real impact. As public records, they can be found by lenders, landlords, and employers and can directly affect your ability to get loans, credit, or housing. Here's the truth. Ignoring a lawsuit guarantees you lose. But if you respond, request more time, or negotiate, you stand a fighting chance. The outcome is up to you. Non-participation has many causes. Many defendants never receive proper notice due to outdated addresses or fraudulent service. Most are unrepresented up to 98% and struggle with the complexity of the legal system. Practical barriers like work, childcare, and transportation, combined with a belief that fighting the case is futile, also prevent them from responding. Default judgments dominate U.S. debt collection litigation, with over 70% of cases ending this way. In these lawsuits, defendants fail to respond or appear in court, allowing creditors to obtain a judgment automatically. This pattern is consistent across multiple jurisdictions. In Utah, 71% of debt cases end in default. Michigan sees 63%. New York City debt buyer cases reach approximately 80%. Philadelphia exceeds 50%. California reports around 65%. And Harris County, Texas, sees 75%. Like and subscribe to support the channel and help us create more new content on litigation topic.